familiar with it for 113 years. And by the time they got around to dealing with it, they didn't want the legislature to be a co-equal branch of government in certain areas where the legislature had proven that it couldn't be trusted and was frequently corrupted by corporations.
And right now you feel that this doctrine of the Counsel, why don't you tell us a little bit about your client, Mr. Knecht, and what brought him to this point? Was it a non-judicial foreclosure? What's going on here?
Well, Mr. Knecht was referred to me by another attorney, and they were in the process of trying to non-judicially foreclose on him. And it was First Fidelity Trust Company, and we couldn't get a hold of him. You know, they sent this notice, this foreclosure notice, saying they're going to take his home, and we couldn't get a hold of him. And so we got all the way up to the court trying to get preliminary injunction, and nobody would answer our call. So the Superior Court granted a preliminary injunction, and when the trustee and the bank finally showed up, they did what they usually do. They tried to remove it to federal courts because they think they get a better rulings.
They think they find safe haven there, yes.
Yeah, and you know, if you look at the studies by the federal court, approximately 92% of those people, these homeowners, that are represented by attorneys lose. Now, doesn't that make you wonder about the federal courts? If 92% lose. And then when you have the pro se people in there, federal courts are pretty much throwing out probably virtually 100%
That's
of
correct.
those cases.
Absolutely.
It's really unbelievable when you look at the numbers. And those aren't my numbers. Those are numbers that come directly from the federal courts. And one of the big things of the time was legislative corruption. I mean, there's no doubt about it.
Article 4, Section 6 specifically delineates the superior courts as having jurisdiction over all issues involving title and possession of land. I think that's one of the protections that's inherent in the Constitution.
That is.
Now, Counsel, I believe now we're going to address Part 1, Sub B, separation of powers on this matter.
The separation of powers are really interesting because the whole purpose of the separation of powers was to protect individuals from the tyranny of a single ruler, but also the tyranny like what occurred in the French Revolution, tyranny of the majority. In fact, if you look where in 1888, the Supreme Court of the Washington Territory, when they talked about separation of powers, they talked a lot about it in relation to the tyranny of the majority or a true democracy. So our our framers, when they got together, they wanted to separate the powers in such a way as to protect the liberty and freedom interests which were declared in the first article of the Constitution, the Declaration of Rights. They put in Article 2, Section 28 of the Constitution, subparts 1 through 18, in which they specifically prohibited the legislature from acting in areas that were comparatively parallel. And they also went so far as to include in that same declaration other restrictions on the legislature, and then other requirements. For example, they required the Washington legislature to enact legislation to protect employees in hazardous industries. So that's very telling. You have the framers giving authority to the courts in Article 4, and you have the framers giving, very briefly, legislative authority to the legislature, but then taking much of that away and telling them how they have to operate. So when you're looking at Washington's Constitution, our framers had lived with a system of separation of powers and were familiar with it for 113 years. And by the time they got around to dealing with it, they didn't want the legislature to be a co-equal branch of government in certain areas where the legislature had proven that it couldn't be trusted and was frequently corrupted by corporations.
And right now, you feel that this doctrine of the separation of powers is, shall we say, pleasantly, or shall we say, if not pleasantly, politely imperiled.
Well, yeah. Take a look at what happened. They go to the legislature and they say, "Hey, if we have to take these people to courts, they have rights, and if we have to follow those rights, it's too expensive. So we want you, legislature, to create an entirely new system for certain lenders that allow non-judicial foreclosures and keep the courts out." Well, I mean, they couldn't do that. The legislature doesn't have the power to do that. Just like in 1979, I think it was, they amended the Constitution to give district courts equitable power. They had to go through a constitutional amendment to do that. In order to create a non-judicial system of foreclosure, they had to create a constitutional amendment. The legislation is not adequate to do that. 2 years after the enactment of the Constitution, the Supreme Court said, look, you can't screw around with this.
And now we've reached the point, unfortunately, where we have to ask ourselves, in terms of the legislature kowtowing to big business or attorneys, we have to wonder if we can ever have this sort of neutrality required by Bain. The trustee should be neutral to the beneficiary when all the major trustees are owned by law firms now who work for the banks.
But what's even more interesting is in a decision by the United States Constitution based on the Equal Protection Clause of the Federal Constitution, they held that you're entitled to a fair trial before a fair tribunal, and they held, and this is really interesting, in 2 cases involving mayors where they moonlighted at night to impose fines, that where the mayor got to pocket the fine, that violated due process because there was impropriety there. And even where the fine just went to the city coffers, that violated federal due process. Well, there's no way what's going on in Washington today, which the Bain Court says we have financially incentivized trustees, and the Clem Court repeats that. There's no way that complies with federal due process.
Of course not. Of course not. It's a substantive due process violation, and of course it follows, the procedural follows as well. But also, in the plain language of the statute itself, I noticed that it stated that the foreclosing entity may only be the beneficiary and owner of the note secured by the deed of trust. Subsequent to that, I'm seeing decisions where certain judges have allowed the holder of the note,
Certain federal.
Federal, to proceed with foreclosure.
The federal courts seem to kind of just ignore Washington law. What's happened is federal courts, of course, are all over the land, and they'll make decisions regarding matters in different states, and they'll develop slogans like, we don't want to hear about split the note, we don't want to hear about this. And you know, they use their slogans as a kind of precedent that applies to state laws. That's completely inappropriate under under the federalism principles and the guarantee of a Republican form of government to each state. Each state has the right to have their court decide it. Now, the Republican form of government is kind of an interesting issue that I'm dealing with the Ninth Circuit, and will be dealing more with. Very early on, there was a question about whether or not it involved a political question that the Supreme Court wouldn't look at. There, a state had enacted an initiative, and they said, well, this is a true democracy, and the court, and therefore violated the guarantee to a Republican form of government, and the Supreme Court said, well, this is a political question. Well, it may have been there, but it's not here, and so we intend to raise it and see what the federal courts do with it.
Indeed.